So basically, what's this lawyer got to do writing on art? And that too 6 volumes on it. So let me quickly tell you what the 6 volumes are. So we have volume 1, which discusses the shaping of the artist, how Ravi Varma creates the image and the life of the artist. You have volume 2, which is the next one there, is after the image has been created, how the image is propelled from the patron to the public. And it is only because of the propulsion of the image from the painter to the public that actually all of this begins to take place. Because just think about it, if for a moment the image never got into the public space, where's the question of copyright, where's the question of obscenity, where's the question of so many other dynamics which we're going to explore today. So it's very important for us to also understand that it is only when art becomes a social voice, just as much as religion becomes a social voice or politics becomes a social voice, that all of this dynamic actually begins to take place. So volume 2 deals with many of the aspects which we're going to talk about today. Volume 3 deals with the divinities. These are the images of associated with worship, your Lakshmis, your Saraswatis, and we also look at how these images interacted with the law. Volume 4, again, which you're seeing over there, deals with the Ramayana and the Mahabharata. This is the largest volume in the series, 385 pages. Volume 5 is Krishna, Leela and Nataka, the Srimad Bhagavatam, the Gita Govinda, the plays like Shakuntala, etc. And the last volume is Power and Enchantment. It deals with images associated with people of power and of course the allure of the feminine. So in all it is 2140 pages on Ravi Varma and the legacy. And what is important is, and this is the question which is also going to be addressed today, is that it's written by an outsider. A lawyer, a litigating lawyer who's writing on art. So in a sense, it's also today's talk is an exploration as to the place of an outsider, the place of a lawyer to deal with something like art. Is there even a space for an outsider? I have a gallery in Bangalore which is very critical of my place in Ravi Varma and has openly said, ask him to go back to court. Why should he be in the art space? So I intend sort of to tell you that maybe my space is here, is not here. And I'm actually going to begin with the very first slide, which is the portrait of Kelike Pat Krishna Menon, Kelike Palat Krishna Menon. And this is an important work within the Ravi Varma space for the reason it is Ravi Varma's first commissioned portrait. Until 1870, when this painting was made, Ravi Varma was an amateur artist. He was a hobbyist. And this painting, he's paid, he's commissioned, and he becomes a professional artist with this painting. Who is the one who commissions him? It's not a Maharaja. It's the person on the extreme left of your screen who was a judge. So the first commission from Ravi Varma did not come from royalty, did not come from the British Duke. It came from a member of the legal fraternity who saw potential in this particular artist. And it is a judge who commissions Ravi Varma, and it is a judge who makes Ravi Varma into a professional artist. But there's another lawyer over here, and that's the little boy whom you're seeing right in the middle. He's KP Krishna Menon, who goes on to become a barrister in the Madras High Court. So you have actually two lawyers in Ravi Varma's very first commissioned painting. But I'm going to take you further on into three other pictures. The one on the left, of course, needs no introduction. We all know who he is. Dada Bennaruji was also a lawyer. But the one which you're seeing on the right top is Justice Muthuswamy Iyer, who was the Madras High Court's first Indian judge. He was also the Madras High Court's first Chief Justice, who was an Indian. And this is one of the people who's patronizing Ravi Varma. And that little photograph which you see at the bottom is from the Kilimanur archive. We don't know if it ever became a painting. And it says, with kind regards, G.P. Pillai. Now, who was G.P. Pillai? G.P. Pillai was again a barrister, because in that photograph you can actually see him in all of his robes, and he, if Wikimedia is to be trusted, apparently was the only Malayali who finds a mention in Mahatma Gandhi's autobiography. So what we are seeing here is that Ravi Varma did interact with many lawyers, many judges. So for those who criticize a lawyer writing on art, I present before you precedent enough to tell you that Ravi Varma and lawyers did interact. Having established that and having sort of justified my presence here in a sense, I am now going to get into what actually happens when art and law interact with each other. And let's look at something which is very contemporary. We all know what happened here. Uh, we had Deepika Padukone's husband. I keep forgetting his name. What's his name? Yes, posing nude. And the minute he posed nude, of course, there were a whole barrage of cases against him by saying, obscenity, this, that, and the other. And when this actually happened, you had Milind Soman who tweeted saying, things have changed little since the time of Ravi Varma. Now, what actually happened here? So what's the actual dynamic? So I have to tell you a little bit of an aside to what had happened over here. So every time Ravi Varma lands up in court, a phone call comes to me by saying, Ganesh, what happened? Is it true that Ravi Varma actually sort of got embroiled into a litigation like this? And the answer is, well, until my volume 2 came out, everybody actually did think Ravi Varma had a court litigation. And this actually became the subject matter of a whole movie called Rangrasya, which had Randeep Hooda and Nandana Sen acting, saying that, here is Ravi Varma in the witness box and he's answering questions in relation to defamation. So when I started writing the book, I said, all right, did this really happen? And I actually found records, and I'm going to share with you this. That is a sketch by Ravi Varma of a court scene. But there's a backstory to what actually happened. So in 1895, when Ravi Varma was in Bombay and he was chaperoning the Prince of Travancore with his brother, they were at the Baikula Club. And when they were at the Baikula Club, what happened is they met two judges of the High Court of Bombay, Justice John Jardine and Justice Ranade. Now, who's Justice Ranade? Justice Ranade is somebody who was involved in so many other things, like trying to revive this Ganesha Utsav. So he's sort of much more than doing just law. And they tell him, tell Ravi Varma, the prince, and Rajaraja Varma, why don't you come to the Bombay High Court and see how we function? So Ravi Varma actually goes there, and that's the sketch of, and it's the only sketch of a court scene. So you can actually see the princess sitting there, and then you have the two judges. In Ravi Varma's travelogue, in C. Rajaraja Varma's travelogue, there is a description of this court case, which is happening over here. And the description says that there was a Pune art dealer who was selling allegedly obscene pictures. And of course, he had been convicted, and the appeal comes here. And the judges get into a very interesting debate. And the debate is, it's a picture of a nude girl who's coming out of the bath. And the judges get into a debate as to whether that girl could be construed as a classical beauty, in which case it's not obscene, or is it not a classical beauty? So the judges actually come to a verdict and they say, if you look at the girl, and I'm assuming that is the actual picture, if you look at the pose of the girl, she looks like a classical beauty. But in the picture is hanging a silken umbrella and her inner unmentionables, and therefore the picture is obscene. So they embark on this complete dialogue as to what is and what is not obscene. And they follow something called the Hicklin's test. And the Hicklin's test is a very sort of it goes thus far but no further kind of thing. It says that if a picture is capable of bringing out sentiments of depravity in people who are susceptible to it, then it is obscene. And this actually resonates even today into the IPC and now the new enactment. Throughout this whole thing of obscenity, I actually asked the question that in today's day and age, and before I embarked on this volume, I said, what is obscene today? How do you define obscenity today? And I sent out a whole bunch of WhatsApp messages to a whole bunch of people and I asked them, what do you think is obscene? Can you define obscene in your understanding of it? After all, law is for the common man. It's not for the grand practitioners in court and all of that. How does the common man understand obscenity? And I'll tell you, I got such a variety of answers that the only consistent thing was inconsistency. No one actually understood what obscenity is because the standard for one person is different from the standard for another person. And it not only was divided regionally, socially, age wise, so even within a family, for example, a senior member would look at it one way, I would look at it one way, my daughter would look at it in a different way. So it was split in every possible way. Then I realized it was split even further. It goes to the extent where if I see a picture and my daughter is next to her, next to me, I'll say, no, 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 it's obscene, don't look at it. But the very same picture in the privacy of my place, I'll say beautiful. So this sort of double standard in relation to obscenity is something which is not between me and another person. This problem with obscenity is within myself in respect of the same object in a different situation. So this whole question therefore is, if you have a double standard within yourself, how do you make a policy standard on the basis of it? And how do you draw the line? And say for this entire sweep of India or the entire sweep of a particular section of society, we draw the line and say this portion is obscene, this portion is not. And in relation to this entire question, in relation to this, it's always going to be continuing. There are other instances which are referred to in the book when Satyam Shivam Sundaram comes under fire. And one portion of them are saying it's perfectly fine, another portion, and it goes all the way up to the Supreme Court. So this question and debate in relation to obscenity is going to continue. Let me move on to the next one. This picture on the left. So it was printed by the Ravi Varma Press. It is derived from a painting by Raja Ravi Varma and interestingly comes under the Indian Press Act proscription proceedings in 1909. Can you tell me, I think I want all of you all to guess. Do you know what the government found objectionable in this picture? Can you just take a quick guess? Look at the picture and tell me, what do you think is objectionable about it? Anyone? Correct. So what? It's actually a bull. But because it was painted or depicted fair, the picture got proscribed and they said, no, it looks like she's killing a cow. Way back in 1909. So for all of these people who are now coming and saying, oh, you know, this cow thing is a big thing. You can't kill cows. It's a new sort of thing. It's not. It went all the way back to 1909. This picture got proscribed. It got confiscated. Fritz Leiher, who was the owner of the press, petitioned the Bombay High Court. And in the Bombay High Court, he explains the picture. He actually describes the whole thing and he says, no, 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 it's Mahishasura Mardini. That is a bull. That is not a cow. And the government then enters into a compromise petition with him and says, okay, you can take the remaining pictures back. But in the later pictures, please make it black. So there are two versions actually in the Ravi Varma Press. This is the rare version where it is fair, and there's a later version where it is dark. And it's because of the intervening of a high court judgment, which actually says, just make him black and you can take the pictures back. So that's a it doesn't end there also. It goes further because when all of this tamasha was going on, the Nizam's government at that point of time bans cow pictures. And there's this huge uproar by saying, how can you ban cow pictures because of that? He says, no, no, we don't want to get into any debate in relation to cow or bull or this or that. We'll just ban everything. And it resulted in such a furor that the Nizam's government had to apologize and said, no, we're sorry. You allow the cow pictures to come back. So it actually went all the way back there. So for all of you who are saying cow, cow, this, that, and the other, it's not new. This is the earliest sort of cow litigation, and it happens because of the Ravi Varma Press and a Ravi Varma picture. This is another interesting thing, and this is serious fun. It features in volume 3. This print. Okay, what's wrong with it? Anyone? It's Subramanya Swami, of course. All of you are silent. Okay, anybody else? So how is it that the previous picture everybody was saying cow this that, but this one no one was able to? No, only one voice I hear. Okay, so there was only one voice of objection there also. In the in the Hindu newspaper, there's a tiny little advertisement which said, I doubt this picture was painted by Ravi Varma. So if anyone can answer, please let me know. It was like a writer, it was a writer's opinion to the editor. But the problem was that little article, and it's no bigger than that. I've seen the actual newspaper, and the article is this big. You'll miss it unless you're looking for it. And it was signed anti-humbug. And this infuriated the dealer. He says, how dare you sign this thing as anti-humbug? So he instituted a defamation case in Madras. And the defamation case got dismissed. Goes all the way up to the Madras High Court. And in the Madras High Court, it turns out to become this hugely contested litigation where the Hindu newspaper is now embroiled in it. And they say, see, listen, you're not revealing the name of the writer, so we will sue you. And every day in the Hindu newspaper, there is a half-page full article saying, this man said that, that advocate said that, the judge said this, then he said this, then it was like a complete soap opera which was being played out in the Hindu newspaper over this print. Who were the lawyers who were there? One lawyer was Shivaswamy Iyer, not this Shivaswamy, the other Shivaswamy Iyer, who was an advocate general. And he was assisted by who? C.P. Ramaswamy Iyer, who went on to become later the Diwan of Travancore. And on the other side, you have A.C. Adam, who was a barrister, who was all these three people were fighting over a print. And the defamation from a print. You're not even talking about defamation of a person. You're talking about some random print. And they're fighting by saying, no, it was by Ravi Varma. It wasn't by Ravi Varma. How dare you say it's by Ravi Varma? It is not by Ravi Varma. But the interesting argument there is, then of course, Shivaswamy Iyer, very, very brilliant man. He says, 1 minute, how can you say it's defamation? After all, what have I done? I have said something about the print. If at all I'm defaming anything, I'm defaming the print. I'm not defaming the seller. So what I am doing, it's not the mischief of defamation, it's the mischief of disparagement of goods. So the split opinion takes place there, that when you talk about an object, it's not defamation of character, it's disparagement of goods. And so finally using that, the petition gets dismissed. So I was actually thinking to myself, this is actually the first defamation litigation in India which is associated with art. But interestingly, it wasn't the first time a defamation litigation actually takes place with art. The first time a defamation litigation takes place with art is actually in London, when Whistler had painted this painting of fireworks. And it was titled A Nocturne in Black and Gold, the Following Rocket. It's a long sort of thing. And one of his critics actually went up to him and then said, you know what Whistler's done? He's cheated the public. It's like as if he took a bucket of black paint and threw it on the public. In other words, he was criticizing the work. And that's the first defamation litigation which takes place in art. The first defamation litigation taking place in India is this. And it is all around a Ravi Varma print. So for all of these people who say, you know, the paintings are more important, no, it's the prints which actually result in this dynamic, the social dynamic, including this wonderful litigation. And you should see the newspaper articles, it's very detailed. Shivaswamy Iyer said this, then this one. And then Shivaswamy Iyer argues and he says, it's not defamation of character. It's disparagement of goods. And this whole thing in relation to the sanctity, as in the previous one, which took place in 1909, comes all the way down to 2023 when Adi Purush comes out. And when Adi Purush, this movie comes out, again I get a phone call from this random reporter who says, "Sir, what do you think of Adi Purush?" Very frankly, I didn't know what Adi Purush was at the time when he phoned me up. So I said, "Tell me, what is this Adi Purush?" He says, "You know, there's a particular actor who's acting for Ravan. And do you think the depiction is correct?" I said, "Why are you asking me?" He says, "No, there's a petition before the Supreme Court questioning Adi Purush. And in the petition before the Supreme Court, there is actually a line which says that the ideal Ravan was painted by Ravi Varma." So this reporter calls me up and I'm having this really bad day. So he says, "What do you think of Ravi Varma's depiction of Ravan? Do you think Ravi Varma depicted Ravan in the correct way?" I said, "Look, buddy, I have to tell you this. I don't think Ravi Varma had tea with Ravan to know how he looked." This guy gets very angry with me. He says, "No, no, no, you're not answering the question." I said, "No." He says, "No, what do you think? Do you think that is the depiction of Ravan?" I said, "Even I've not had tea with Ravan to know how he looks." The guy gets really irritated with me. He says, "Sir, you're not answering the question." I said, "I'm sorry, but you're not asking the right question." He says, "What's the question?" I said, "Should an image remain static or can an image be fluid? If it is static, the problem is going to be, is Ravi Varma's correct, a 10-headed one correct, some miniature correct, some sculpture correct? We will never know. But if it is fluid, any Ravan goes." But what did this actually bring out? This whole, of course, finally this litigation gets dismissed. Supreme Court rejects it. But what does this whole sort of thing bring out? It brings out the fact that Ravi Varma's image, especially in today's day and age. Now, I have to sort of lodge the caveat here and tell you that this 2,140 pages is not a hagiographical narrative. It's not deferential to him entirely. It's an analytical understanding of the legacy. And I find it curious that if you look at litigations like this, how Ravi Varma's image has become sanctified. So much so that today not only is the Uttam Ram by Ravi Varma, the Uttam Ravan is also Ravi Varma. So it's an interesting social dynamic as to how Ravi Varma gets placed within this whole sanctified image. And whether you can question Ravi Varma, whether you cannot question Ravi Varma, I think this is going to be a sort of wonderful analysis as we see things going on. I'm moving into something else. And this, of course, is the poster of the event. The Radha chromolithograph was issued in 1895. We do know it was issued in 1895 because it's one of the rare ones which actually have the date at the bottom. It says printed 1895. And exactly a year later, the Hindi Punch carried another sort of satirical, it not satire, but it carries a cartoon. And in the cartoon, it's titled Grandmothers of 30. Now, I'll tell you what was happening at that point in time. I'll tell you. So the entire cartoon is actually a very interesting cartoon because it is one lady is speaking to another lady and the entire dialogue is written down there. She says, "Why are you looking so, sad?" And the other lady says, "I'm a grandmother at the age of 30. And she says, "So why are you upset about it? You've reached the pinnacle of your family by then." She says, "No, I was in and out of life before I knew it. It's time to change the marriage laws." What was happening at that time? At that point in time, the lady which you're seeing on the extreme left is a lady called Rukma Bai. There's actually a movie of Dr. Rukma Bai, which is after this lady. And what had actually happened was, in those days, you had child marriage, right? So this girl got married when she was very, very young. And when she came of age, she refused to go to her husband's house. The husband thereafter filed a petition, what we in legally is known as a petition for restitution of conjugal rights. He says, I don't care. She is my wife. She better come and cohabit with me. The petition, after a lot of contest, actually came to be allowed by the Bombay High Court. And she refused to give up. She says, no, it's my choice as to whether I go and cohabit with this person, because I got married when I was a minor. I didn't even know what I was getting myself into. The story goes, she petitioned Queen Victoria, and Queen Victoria finally annuls the marriage and says it is her right to marry or not to marry, cohabit or not to cohabit. And then she goes on to study. She becomes a doctor and is said to be one of India's first women doctors. She comes back and she becomes a very, very famous doctor. It is at that time that the cartoon comes out. And the cartoon is expressing the view of women by saying, look, if you don't get your act together, because by that time the age of consent act had already come, if you don't get your act together, what is going to happen? You're going to have grandmothers at the age of 30. And this is where art pushes the legal narrative and says, look, you better get your act together. And then, of course, it moves on and on and on until now we have 18 and 21. But at the time when it was really at its peak, it was a Ravi Varma image which was actually used to make the point that you better get your act together in relation to the age of marriage. We look at another very recent example, and this does not feature in the volumes. Why? Because these are copyrighted images and I needed copyright permission to use it in print. I can use it in an academic talk. What was happening? 2012 December, let me get that date right, was Nirbhaya. We all know what happened. It was such a traumatic experience. The girl eventually died. The Domestic Violence Act was already in place. But clearly, people had not understood what the Domestic Violence Act was all about. And so this advertising company called Taproot in Bombay at that point in time comes out with these posters, the whole series of them. And they came out with it and they called it the Abused Goddesses Campaign. And in the Abused Goddesses Campaign, they condemn domestic violence. And take it from me, 2 out of the 3 images are from Ravi Varma's. They take the mold, especially the Saraswati, is almost an exact replica of the Ravi Varma Saraswati. And it had a very powerful slogan. It says, pray that we never see this day. Today, more than 68% of women in India are victims of domestic violence. Tomorrow, it seems like no woman shall be spared, not even the ones we pray to. I'm given to understand, was a very, very powerful campaign, so much so that even Huffington Post carried it. But I have to tell you, I thought it was a very, very powerful campaign, and I wanted to feature it in volume 3. And when I wrote, of course, Taproot by then had been taken over by another company, spoke to the lawyer of that company, and I said, see, listen, I need this image, because I was getting no response from them. My publishers needed copyright clearance because these are all copyrighted images. And the managing director came up to me and said, sir, please don't use them because we're ashamed of the campaign, which I thought was extremely insensitive because I thought it was a very, very powerful campaign. And it showcased that this is exactly how, one, of course, how art and law and art is actually propelling a, a statutory statement. But they said no. So I decided, all right, I'm going to use it in all of the academic talks because academic talks are, Copyright Act doesn't exist. Here is such a powerful campaign, something where 1897, 1896, I showed you the previous one where we're talking about the rights of women, age of marriage, and we're still using a Ravi Varma image as of today to show women and their rights. So I'm moving on to the next one. We're talking about dark skin. And we all know the problems in relation to the way in which certain people associate fair and dark skin. What is interesting is that way back in 2019, you had Naresh Neil come out with a campaign uh, which specifically said, why should we depict divinities as fair deities? And it is about a year later. This actually happens much before. It's a year later that the government actually puts in a bill to say, listen, if you show fairness creams, you may be liable to a punishment. Of course, that bill didn't go through. But what I'm trying to get to is that art was a step ahead of law by actually saying, say, listen, we should somehow bring about a parity in so far as skin complexion is concerned. I'm moving on to the next one, and this is copyright. I'm sure copyright is something which all artists are asking questions on what actually happened. But copyright and art actually had a very nasty history. As early as in 1850, the British government is actually petitioned by the Bengal Photographic Society and say, will you please bring in copyright laws in relation to art, engravings, photographs, etc. And nothing actually happens until finally the owner of the Ravi Varma Press, his name is Fritz Leicher, he's the German who finally buys the press. And he says, nothing's happening. We are petitioning the government over and over again to bring in copyright in relation to art, but nothing's happening. And he actually proceeds to the Bombay High Court and he says, listen, we've had enough. We have to have this stopped. But even the Bombay High Court, which you're seeing over there, it says that, no, I'm sorry, we can't do it. Because the Lakshmi doesn't belong to you. The Lakshmi belongs to everybody. And this happens in 1913. It's only in 1914 that an amendment is brought in and engravings and photography and all of that happens. So a lot of people actually ask me, is Ravi Varma copyrighted? Is only a particular foundation the only source point of Ravi Varma? The answer is no. Why? Because Ravi Varma died in 1906 and the amendment actually came in 1914. So even when Ravi Varma was alive, Ravi Varma's images were not within the space of copyright. But this question in relation to copyright came up now very recently. And I'm showing you this not in relation to Ravi Varma, but I do want to hear during the Q&A the views of some of the lawyers who are sitting over here. So let me tell you what happened. Yusuf Arakal, very famous artist in, especially within the Bangalore region. He died. He was survived by two heirs, the widow and the son. And when an exhibition of Yusuf Arakal's works was to take place here in this building, the son filed a suit for an injunction and obtained an injunction because he said, I own substantial copyright. The exhibition was stalled. After the period of the exhibition was over, he simply withdrew the suit. After that, what he does is he sends notice after notice to every gallery, in stateable gallery in India, and he says, I own substantial copyright of Yusuf Arakal's works. This, I've already obtained an injunction over here. You will not use Yusuf Arakal's works anymore without my permission. These notices came to me and they said, Ganesh, what is the answer? There was no answer. Why? Because copyright technically is an indivisible right. It either exists in entirety or it exists not at all. If you have two exact LRs, one saying yes, you go ahead, and another saying you don't go ahead, how are we to make it apply? Are we supposed to tell people, listen, you can buy a print, but half of it you cover up, half of it you can see? Or do you take the entire estate and say this portion of it you can use, this portion of it you cannot use? This question in relation to copyright, what I'm trying to get to, is now becoming a huge thing. And especially in relation to art, we have a lot of questions which are undecided. We still have to see how this thing plays out. There's another dynamic, which also I think the art community here should understand, that if Yusuf Arakal's son was to hold on to copyright and say, no one will use copyright, no one will use the image, and he does it for 60 years. In 60 years' time, Yusuf Arakal will be all but forgotten. No one will know who he is unless you're talking about him, unless you're publishing about him, unless you're debating about him. Yusuf Arakal will be forgotten. So this dynamic in relation to public domain and copyright has to be carefully navigated. It cannot be sort of, you can't hold it by the scruff of your neck and then say, no, none of it is going to come out, because 60 years is a long time in public memory. Yusuf Arakal will be forgotten if this is the kind of strategy which takes place. Which is why if you see my view in relation to Ravi Varma, I say it's in public domain. Anyone can talk about it. It's not one particular organization only which has the right to do it. Why? Because one, of course, as I said, Ravi Varma is in public domain, is because culturally, law has to slightly take a step back. And this is where the interaction comes in between art and law, that law cannot go to its logical conclusion insofar as copyright is concerned, if the cultural space is to survive. So that dynamic, I think we're going to keep seeing going on. We are moving on into the last sort of segment over here. Way back in 1987, Jaya Bachchan orchestrated this Bharatanatyam dance ballet. And what was she trying to do? What she was trying to do is she was trying to mainstream children with special needs. Today, what we call special needs. But in 1987, so what she actually did was she had this whole series of tableau vivants using the Bharatanatyam dance poses, using Ramayana and using Ravi Varma. And she was trying to mainstream these children by saying, okay, you also participated in it. And I saw this newspaper article in the 1987 Times of India. But in 1987, just think of what children are special. Today we call them special needs children. But at that point of time, when I'm reading the first paragraph, it says, it has to be seen to be believed. A dance ballet on the Ramayana by the handicapped, deaf and mute, blind, orthopedically handicapped, and mentally retarded. This was a public statement. To call somebody mentally retarded in a public forum today is just not acceptable. You can't do it. So society has gone through this process of sensitization by saying, look, we need to start mainstreaming everyone. 1987, Jaya Bachchan starts it, and just sort of the last but one paragraph, it says that, the last paragraph, it says, another deaf mute Kashinath did a convincing Bharat in the concluding coronation scene, which was an authentic Pattabhishekam recalling the classic Ravi Varma. So again, Ravi Varma and Ramayana comes to be used to sensitize society in relation to mainstreaming children today with special needs. 1987, that happened. The first enactment in relation to equal opportunities was a good 9 years later. Until then, even the legislature was not really quite thinking about what to do. And then, of course, it comes into the new enactment. I was very curious as to how this conversation is being brought to the present day. How do you take art to a person either with low vision or blind? And a very dear friend of mine is doing this. Okay, so here we have, of course, the rights of persons with disabilities. This is the new enactment of 2016. And look at what the preamble actually says. It says respect for inherent dignity, full and effective participation and inclusion in society. This is what the enactment is trying to do. But how does art do it? How do you take visual art to the visually impaired? And I have to tell you, there's a fantastic, you know, a fantastic work being done by this boy called Siddhant Shah. And what you're actually seeing is that there's a Kadambari that is by this one of Ravi Varma Press. And that boy is blind. And what they've done is they have this whole tactile thing over there, and you can, it's described saying, you know, here is a girl, she's sitting there, she's holding a veena. And on the left, the boy can actually touch the veena and can feel it. If you can't see it, you can at least feel it. Now, I have to tell you, I'm completely in awe with what Siddhant Shah is doing. I think he's doing fabulous work. He's a good friend of mine. And when my book was launched in Baroda, he says, Ganesh, I have a gift for you. I said, what are you going to give me? He says, I'm giving you my tactile Lakshmi. And I want to show you the tactile Lakshmi. And what I want you all to do, and what I want all of you all to do is after this is to come and feel this, because that's what you're supposed to do. Close your eyes and you can feel every bit of the crown. You can feel the lotus, you can feel her sari, you can feel the elephant. And if you know Braille, you can even say that's an elephant and that's Goddess Lakshmi. This is how art is actually taking the statement of an enactment and making it real for people. So ladies and gentlemen, this, I'm hoping with this and this, what you've seen on the screen, you understand that actually law and art, culture are not too far apart. One has assisted the other has assisted this. Both have evolved simultaneously, both have lent to each other. And if you bring these together, you can actually see much more than what you're actually seeing on the screen. So ladies and gentlemen, with that I conclude. Thank you.
Sorry, this is actually slightly unrelated, but the Bombay High Court case with the coverage in the Hindu, was the right to stay anonymous, was that eventually recognized, or
Which one? Sorry.
You initially showed as an image something in the Bombay High Court litigation, which involved some under a pseudonym, a
Yes,
comment was
the
made.
person was identified, was brought in as a witness.
Right.
It wasn't in the Bombay High Court, it was in the Madras High Court.
I see, sorry.
So it happened to be, and that's an interesting other dynamic which gets into art, is that the person who had written the article apparently was a follower or was an art teacher, follower of Ravi Varma, knew Ravi Varma very well. And the reason why he actually said it, of course, that portion I don't get into, is because Ravi Varma apparently told him, I will never paint a Subramanya. And there was a letter which was exhibited in the thing. That letter comes to be exhibited, in which Ravi Varma says, I don't want to paint Subramanya because I can't accommodate 6 faces and make it look straight. So that, of course, gets into a completely new dynamic in relation to what is called intentionality in art. So, you know, this whole debate in relation to intentionality is the intention of the artist or the maker relevant? Or after the artist has made or the author has written, does the intentionality then subsume and the intentionality of the reader take over or the viewer take over? Is the intention of the artist, must it resonate with the viewer? And Roland Barthes has written a fantastic essay. He says, death of the author. He says, no, we are not interested in what the artist thinks because the artist has made it and gone. And the only involvement when the artist is there is when he's making the picture. After that, we are not supposed to look into what the intention of the artist is. It's all about the intention of the viewer. So the intentionality debate is a very interesting one, which also sort of emanates from there.
Just a follow-up question to that. I mean, you mentioned the intentionality thing. There's a writer named Ananda Kumar Swami who's written a lot on aesthetics.
Correct.
So it just struck me. I didn't have a question. Just a follow-up to what you mentioned. So in that, he says, in order to appreciate beauty, you know, we all often look at a painting and say it's beautiful. He says that's the initial reaction.
Correct.
You know, but he says that the only way you can get close to that is if you can come somewhere close to understanding the original intuition of the artist.
Correct.
He uses the word intuition.
Correct.
So it just struck me because even when you're looking at any sculpture or any painting, what is the original intuition that the artist had when he painted it. And only then Kumaraswamy says that you can really appreciate beauty.
Correct.
So what is your take on that?
So
And
that,
just one follow-up, one small thing.
yes, please.
Indian art, there's always been this blending of the sacred and the sensual.
Correct.
So why is this such a big deal, culturally?
I'll tell you. I'll answer both of the questions. One is intentionality, intuition, and the creative genius of the maker. Right. So that's the starting point. And then it moves on, and then it somewhere disappears, and then it's all about the viewer and then how other people look at it. Unless and this is debated in volume 3, especially in relation to the religious images. Kumaraswamy says that if you are unable to gel with the intent of the artist, you've lost the plot. That's effectively what he says. Sort of, I don't want to get into his very complicated understanding of it. How I look at it is different. One, do you know what the artist intended? Most often you don't. Point number one. Point number two, it doesn't matter because it's not the artist who exists, it's the artwork which exists after him. And that's what we are interacting with. We are interacting with Ravi Varma's chromolithography. We're not even interacting with the painting. So does it matter? This is question number 2. Question number 3 gets into a much, much larger dynamic, which you will find in the preface of volume 1. I'm going back into that because I'll tell you, when I had finished my research for the volumes, I had something like about 12,000 images on my laptop, and I had my my structure of the book running into something like about 7 lakh words. How am I supposed to structure this? So the first question which I ask myself, which is what all of us lawyers do, is we want to know what the base argument is and then we build around it. And I said, what my base argument is going to be is democracy. I'm going to explain democracy. I say that, and I argue that in the preface of volume 1, I say that democracy is not restricted to power only. The previous century, in which I'm sure most of us were there, the previous century, the early half of the century to the latter half of the century are in diametric contrast with each other. Early half, you have monarchies ruling. At the end, you have democracies almost swaying, not only over India, Europe, everything. Early half of this century, religious places were under the control of very few people. Later on, that gets opened out, so much so that today you're even debating whether women can enter Padmanabha Swami. I'm not getting into whether it's right or wrong because it's before the Supreme Court. I'm just saying that that is the endeavor which is being made. Early half of the century, wealth is in the hands of a few. Through the century, through something which we call distributive jurisprudence or legislations, Privy Purse is abolished, Urban Land Ceiling, Reforms Act, Income Tax Act, so many acts, wealth gets distributed. The question therefore is, if power, religion, wealth, information, all of it is going from few to many, few to many, few to many, how could art not have done it? It was that transition which the whole century encapsulated. There was no way you would put your hand up to the tsunami. So you go back now to Kumaraswamy. Kumaraswamy tenders his opinion when, at the time when the first phase of the century was there, where elite opinions mattered. But later on, elite opinions become insensitive. Today, if I were to say a particular space is very exclusive, if you want to see Ravi Varma, you have to drive in an Audi car and come. We will give you the finest pours of wine. Then only you can see Ravi Varma. Do you know how insensitive that would be? Because today, it's not palatable to do it. So today, whose opinion matters? No longer the elite, the democratic person. So Kumaraswamy today now, that's the argument. Kumaraswamy now is relegated to that portion of the century, no longer applicable to us today. What was your second question? Correct. I'll tell you about everything. So in 1875, these central archives in Delhi, the British government were redoing education policy in India. It's a huge file, it's about this big. I was reading it because I wanted to know where we stand in relation to the policy in relation to sensuality. And the one line in that whole file caught my fancy. It said, to place the Arabian Nights before an Indian is, sorry, to place the Indian epics before an Indian is as bad as placing the Arabian Nights before an English domestic circle. That is what crystallized our understanding of sacred and sensual for over what, 1.5 centuries today. It's nothing but Victorian prudery. The Indian non-judgmental, non-binary understanding of sacred and sensual has become binary, judgmental, black and white. It is the colonial understanding of it, which started in 1895 and till today we're not able to break out of it. A very dear friend who's also an author, J. Sai Deepak, very good friend of mine, he says, you know, Ganesh, we have to shake away from the colonial mindset. I said, fair enough. I understand that you want to reinvent India. Can you remove this? You can't, because you and I may be very non-judgmental about it, but you go down to the common road, you can't be non-judgmental about it. Do you know how much moral policing is going on? It is because of that 1895 sentiment which is now in us. How do you debate sacred and sensual? Again, we come back to the argument which I made in relation to obscenity. In private circles, you can debate it. In public circles, you can't. Yes.
Hi. Just curious, since you spoke about one of the themes being democracy and social reform, and how art often led movements of social reform,
Yes.
much before law did. In the context of Raja Ravi Varma, what is your view of, did he as an artist lead social reform in any area, through his artwork?
So there are two aspects to Ravi Varma's legacy, which most people have not quite understood. One is Ravi Varma's paintings. The second is what the Ravi Varma Press does. So the Ravi Varma Press was a different entity altogether. Ravi Varma lent his paintings to the press printed them, they went on to come into our spaces. Ravi Varma as such, he was a great diplomat. And he understood that at the time when he was living, the British and the Indian Maharaja were almost of equal powers. And they were always vying with each other. So because at the time, somewhere towards the end of Ravi Varma's life, you have Saiji Rao Gaikwad flaunting the British in the Darbar and all of that. But Ravi Varma would not have participated in any of that. Because Ravi Varma knew, I don't think, Ravi Varma lived at a different political time. Ravi Varma per se would not have pushed anything, but the Ravi Varma press did. And a lot of the debate which you're seeing on the screen now is all because of the Ravi Varma press and the printing which took place. And the Ravi Varma press, in fact, a lot of the presses participated a lot in things like nationalism, bringing out the Bharat Mata, trying to reimagine a female Indian. And they go into all kinds of complications because in one sense, Bharata is a male, but Bharat Mata is a female. How did that transition take place? We don't even know. So the Ravi Varma press and the printing establishments participate, but Ravi Varma as such was a great diplomat. He would not have offended anybody. He played his cards very well. But subliminal messages you do find, suddenly you will find, for instance, in Varaha Avatar, where the globe is being taken up. You see the globe, one big India is there. You can only see India and the globe. We all know that geographically it's wrong because India was much, much smaller. So maybe subliminal nationalist messages were made, but later people interpreted the Lakshmi to be the Indian image. The sari became the metaphor of India. And Sumati Ramaswamy has written extensively on how when the Bharat Mata image was created, they didn't know how to show the boundaries of the nation. So the sari went and became the boundaries of the nation. So the sari became the metaphor for Indianness. But that none of it had to do with Ravi Varma, it had to do with the later people. Yes.
So, sir, thank you so much for the talk. I really enjoyed it. And something that you said in the beginning was art is a social voice, when art becomes a social voice. I wanted to understand your perspective on when art becomes so, like, through your presentation also, I understood how art precedes law in a way. Am I?
Sometimes art went ahead, sometimes law went ahead. Yeah. So you have both examples.
So, I want to know in current times where art has become a voice of revolution against law. For instance, let's say Faiz Ahmad Faiz's poetry being recited, or images of the Constitution, or certain Instagram memes or pictures that are being used as art against law, like the CAA or the NRC, or art as
Was art used?
I I would say it was.
I have not seen examples of art being used. Art being
Perhaps
used as memes, I have seen.
not, maybe not visual art in the way you, but I would say poetry is art.
Listen, okay, let's just step back a bit. When you are looking at social voices, this whole debate, and I'm sure she will also agree with me, this whole debate is who is it for? Who is art for? Who is law? Who is art for? Is it only for the practitioner? No, it's for the public. Who is law for? Is it only for the esteemed practitioners in the red building? So much so you can come out with so many gymnastic judgments that most people don't understand it? No, it is for the common man's understanding. The language of poetry, the language of cinema, the language of so many other things all lend to that. Now, and it has been used. It has been used extensively to make social statements. It has been used to disrupt, and disruptions we have seen happening. The whole question is, if you take individual instances, we can say whether it's right, wrong, this, that, and the other. But the large parameter will always remain that you can only go thus far and no further with law. So you can't, for example, antagonize a community simply because you believe you can antagonize a community. Then you be reprimanded. But if you're making a larger statement, then possibly you can. I'll give you the example of, now I've started reels from Jan 21st. I started doing, and I'm calling it reeling Ravi Varma because I thought we'll do this hip thing. And I did I think 2 weeks ago, I had this reel on Article 370 in the Supreme Court's judgment, and a textile label from the Ravi Varma Press. And I correlated both of them because if you look at what the Supreme Court says, the Supreme Court continuously uses the word integration, 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 thereby somehow diluting federalism and saying, oh no, at the end of the day, all of us are sort of one. And how a Ravi Varma label way back in the 1910 or something like that is also saying the same thing by saying all of us are one. So in that sense, yes, you can correlate it. But again, generically to tell you, it can go only thus far, but no further.
Good evening, sir. Thank you so much for the lecture. I just had a quick question about legality versus legitimacy, right? When it comes to art, art sort of pushes social reform beyond what is legal. But if you look at the history of legality, especially post
Use the
the
word morality.
no, I would like to specifically talk about the law because I would like to talk about the Constitution. That was what my question was relating to. The Constitution was emancipatory and transformative in a way that very little law had been beforehand, and that was in a way where it would didn't really reflect what the majority of Indians would have thought even possible in 1950. Right? It was an instance of the law going forward beyond what was legitimate
In
or
what sense? Give me an
legitimate.
example, because
So when
if you're
I
looking
say
at the Constitution, how it comes to be made, this, that, and the other. We all know that the Constitution is not meant to deal with intricacies.
Right.
And the Constitution cannot deal with the intricacies. It cannot tell you what's going to happen 200 years later in relation to some incident which takes place there. It's a very generic document, is always intended to be a generic document.
Of course.
So unless you give me instances of where you think art collided with it.
Right. No. So specifically, what my question was with relation to the way the Constitution was formulated. It gave importance to a series of rights that otherwise wouldn't have been deemed legitimate. As in the majority of. So when I say legitimate, I mean what the majority of Indians would have accepted at the time, because the majority of Indians didn't really have an understanding of universal adult franchise, of fundamental rights, of all of that stuff, right? And what we've seen recently is sort of a pushback to the majoritarian approach, which is when law has sort of succumbed to what the majority believes is legitimate.
In what, in which instance?
Uh,
Give me an instance. It's fair enough to be generic about it, but if you're looking at a generic argument, the generic argument is we are a democracy which is largely majoritarianism.
right.
So in that sense, if you were to look at it from very, very large perspective, there's nothing wrong in what is going on. Unless you give me an instance where you say, of course, subject to rights of minorities, all that which are also enshrined in the Constitution. Generically, if we look at majoritarianism, that is what we are. That
Right,
is what
but sort of art has sort of served as a counter majoritarian view and has sort of pushed back against majoritarianism, across countries,
Give me
across
an
times.
instance. I mean, pushed back against the majoritarian view. The instances which I can only think about is, I mean, instances of obscenity, which I just mentioned, that, majority's view or the common man's view is one thing, but the elite view will always be something else. Unless you have another instance, which I'm happy to hear.
No, so I was actually also talking back about the sort of way art is used as a form of protest, right? Again, with art in a variety of different expressions, basically fundamental expression being used in a variety of ways to counter a majoritarian view. Was what I was looking at.
I think Ravi Varma, if you're looking at Ravi Varma, these are the instances where certain public opinion was fomented, like in the instance of what is that, the Domestic Violence Act or something like that. But to counter a particular political view, yes, actually at that time Ravi Varma's was being used. Kichaka Sairendri, for example, it doesn't feature here. Kichaka Sairendri, for example, was actually highly disruptive because Kichaka was symbolic of Lord Curzon. And Sairandri was supposed to be India, and then him trying to sort of do away with her or something like that. So protest images have been there. Markandeya, for example, actually, if you can pull up volume 3, it's here. Markandeya, for example, was also used to show how Mahatma Gandhi was protecting Mother India, which in those days would have been hugely sort of, people would have said how, let me show you one of those. This one. This comes in volume 3. I don't think it went down well with the British at all. So that way, yes.
Yeah, I have a question.
I can't see the
Here,
person
here,
who's
here.
asking. There. Okay.
Yeah.
Yeah.
I mean, considering that we're now moving into an era where the creation of art is being democratized with AI, where pretty much anybody and everybody can now create art that looks absolutely legitimate, as good as Raja Ravi Varma's, can even take Raja Ravi Varma's art and manipulate it to slight degrees, to greater degrees, and nobody will even know the difference. I mean, in such a situation where you don't even know, and there are so many players, right? With AI, there's a person who's writing the prompt, there's a person who's coding in the back end, there's a data set itself, which is highly questionable. Who is actually the creator in this situation, and who is actually responsible when, I mean, there's some misinformation or disinformation that goes around? Who actually would you say is responsible, and how is law going to respond to this situation?
Okay, good question. I was actually asked this exact question by Money Control. And so I know the answer. So and I got reported also on that. Who was the reporter? Jayanti Madhukar. She phoned me up and she says, where does originality stand in AI? And therefore, can AI get copyrighted? Okay, it's actually a very confusing question. So I'm going to go through and confuse all of you. My answer was, and it was a very logical understanding of what it is. I said, look, in order to get copyright, you generally need two things. One, you need a maker, and you need something which is created, which is original in content. These are largely the two requirements for you to entitle you to get a copyright, right? Now, if you look at AI, I said AI, in my understanding of it, is entirely orchestrated by human prompts. All the information which gets into AI is human generated. You're not agreeing with me? Yes or no? Okay, right. So if all of the prompts for AI is human generated, AI's rendition of it can never be original. You're not agreeing with me? Now give her the mic. I want to hear her opinion also. Because at the end of the day, these are new aspects which we're going to see.
I mean, when a third image gets created and that image takes parts of, let's say, two Ravi Varma paintings and
Okay,
puts
so
half.
can I continue the argument?
Yeah.
So what I told her is, if you go step by step, at this level, there's no originality. But let's move stage 2. Stage 2 is, okay, let's just look at my talk today. Okay, let's just take the example of today's talk, which is going on over here. How much of it was actually new stuff for all of y'all? Okay, how many of y'all thought a lot of new stuff? You know, this is all Ganesh's. Raise your hands, come on. Okay, quite a few of you. Right. Let's dissect today's talk. I speak to you in English. I didn't create English. I did not promulgate any of the statutes. I'm not Jaya Bachchan who did that. I'm not Siddhant Shah who did this. I am not Hindu Punch which did that. I am not Rukma Bai who fought for it. I am not this, I am not that, I am not that. What part of today was original?
Only the analysis.
You can come down and say nothing was original. What
I mean,
I'm doing today,
wouldn't you agree that the
no,
curation was
let me
original?
just finish. What I'm doing today is only a retelling of what maybe all of you had forgotten, all of you had not known about it. What I'm doing is a retelling. This is one way of looking at it. Okay, one way of looking. If that argument were to be there, no historian is original because he's writing about somebody else. That is the only fellow who can claim copyright. The historian is not original. He's only retelling something which already, this is one argument. Right. Here's the second argument. You take carrots, you take squash, you take onions, you take coconut, and you make an avial out of it. Is the avial original in its own way? Yes. But if you dissect it to all of its ingredients, it's not original. When therefore, now we come to your AI argument. When therefore do you cross over the threshold by saying from derivation to original? It's on a case-to-case basis. If you were to go back into the argument backward trajectory and then say nothing is original, it's not an unknown concept in law because most Orientalist cultures will tell you that intellect is not original. Somebody teaches you something, somebody else teaches you something, somebody else teaches you something. And this is how this collection of intellect takes place. There's a Sanskrit slokam which says prakrute swabhavat. It's an adjunct of nature. Which is why Orientalist culture somehow believe that knowledge must be free because you never invented it yourself. So even there, it's not an original argument. It's an old argument which says somewhere there's play between copyright, originality. Then you can ask me, Ganesh, then where is copyright? Copyright is there only because the statute book is telling you that. Otherwise, ancient Orientalist wisdom does not believe in it at all. It believes in larger intellect. So in AI, When does a derivation jump over and become original? It's on a case-to-case basis. We'll have to see how AI evolves. You're still not convinced.
Yeah, I mean,
No, I want to hear because AI is new. I may be also wrong. This is what I told Jayanti. I said, Jayanti, we don't know where it lies. If you're looking that AI is all based on human prompts, then AI is not original. But who's making the derivation to make it into original? I don't know.
okay, got it.
We'll have to see, like this copyright and use of Oracle, we have to see how the law evolves. AI and copyright, we have to see how the law evolves. And I'm hoping people actually deliberate over it in court. Yes.
Actually, I kind of agree with her. So prompts are basically the themes that you're feeding into the AI, but the AI itself is creating its own art.
Correct.
So it's not entirely scripted, and it's just few hints that you're providing here and there, which enables the AI to create its own art. So it is creative in its own way, right?
So that is where the debate is going to take place. Where does a derivation jump over the threshold and become original? It will be on a case-to-case basis. It won't be all of it.
Okay, leave alone the AI. Even humans in that case wouldn't be original in their true
Correct.
sense.
You're absolutely right.
So
That's why I took the example of my talk.
okay.
That's why I took the example of my own talk when I'm saying you may think all of it is original, but if you break it up into pieces, none of it is original.
Okay.
So it's either all or none here. We have to see what AI comes up with.
So there's no true creativity in general.
There is, in my opinion, if you look at Orientalist cultures will always tell you that there is no true creativity for anybody. What if you say that you are truly creative? It's your ahankara which says it.
Okay.
If you go down really into an esoteric level and then they will say, who are you? Orientalist cultures believe in that concept, you know. Take for example, what is that shlokam? Kayena vacha manasendriyerna va buddhyatmana va prakrute svabhavat karomi yat sakalam parasmai narayana samarpayami. What you think, what you do, what you this one is an adjunct of nature. Therefore, what you do goes back to Narayana.
So you're concluding that God is the only true creative person.
Nature.
Okay.
Prakruti.
Which is God in your case?
That it depends. To me, of course, everything is Sharadamba, but to somebody else, it may be something else. I don't judge. A higher intellect.
But the way we interpret things is also creative, right? We are not.
See, again, true. This is why when it comes to originality,
Okay.
it is when does it jump over the threshold? When does it become incremental new knowledge? And it is on a case-to-case basis only. Even the greatest sages have said, this is not original to me. I'm just retelling you something which was already said years, eons ago. Like I'm doing now.
Okay.
Technically, if you see, maybe none of mine is original. But when you walked into the room and you heard me, I have never heard of this before. You're saying it's original, but if you break it up into ingredients, it's not original.
So what is your stand on copyrights? Coming back to the original point.
It's on a case-to-case basis. And the only reason why you are entitled to copyright is because it exists in the statute book. Otherwise, no. It's an artificial right. It's an artificial right created by the statute book, which is why you get it.
Just to follow up, I mean, there is the famous saying that if you give 1,000 monkeys 1,000 typewriters, one of them is going to prompt out Shakespeare, right? I mean, does that mean the monkey gets the copyright for Shakespeare's works?
All of them get copyright for whatever crap they came out with, so it's okay.
But the point I was trying to get to is that, of course, inspiration plays a very real role in all creation. But when you look at originality in the process of creation, there is an ounce of human ingenuity that adds, right? Human consciousness, human ingenuity is what creates, and that isn't something that we've found replicable in machines. So
that was
the originality sort of stems
to
from
him. That was the argument. And to the lady there, I said that if human ingenuity is inapplicable to a machine process, AI does not get. However, both of them have argued by saying there are certain algorithms which reinvent the information already fed into the system to come out with something original. So we have to see how it evolves. If, see, AI is very new. I'm sure you all want to know answers, but we don't know. As much as we don't know what's going to happen to the use of Oracle split copyright, there are many things we don't know the answers to, but these are debates which are going to happen, are going to take place, and this is how it's going to. Like for instance, take NFT. It went up and down and it collapsed, and now no one knows where it landed up into. Even Ravi Varma went through that whole thing. Some person did NFTs and no one knows where it languished in now today. And there was a whole debate in relation to who holds the copyright for NFT. There was a Supreme Court, not Supreme Court, there was a Singapore version which says that the NFT generated a copyright completely new of its own because it was a completely new medium. We didn't know. Fortunately for us, NFTs, you know that there's that poem by, I think, Browning or something, is it? Unnumbered suppliants, crowd preferments gate, a thirst for wealth and a burning to be great. That's what NFT did. Delusive fortune hears their incessant call, they mount, they rise, evaporate and fall. That's what happened to NFT. So there were some people who participated in that whole Ravi Varma NFT bandwagon, they evaporated and fell. So we never actually got into a judicial pronouncement on any of it. But AI, I think we will, because it seems to be a little more stable.
So coming back to the example which you gave earlier about the avial.
Of
Avial.
Avial, huh?
All the vegetables you put together and you get avial out of it. So the vegetables are merely a medium out of it. In a way, you can say like the artist used canvas and paint are a medium. Any painting can be broken down into RGB, just plain colors. We didn't invent colors. Of course, God did it. But the way we compose it, that is the creative part. The message that it conveys, that is the creative part, right? It can make,
She's a Malayali, she'll tell you.
you can make avial, porial, palya, anything out of the vegetables. You got the point, right?
Yeah.
It's a creative composition
Correct.
of the Keralite originality. The same thing from a Tamil originality will be a porial.
See, listen, I can't argue with
So-
her recipe on avial, so I have got to. I'll hear it from her. I can tell you the minute I leave. So, yeah.
The point I'm trying to make is the message, the composition of the original ingredients is the creative part, not the ingredients itself.
So one view has been that when the derivation is of a completely new characteristic, it is original in its own form. I'll say that again. When the resultant thing, for the lack of a better word, has a characteristic which is so unique to itself, it is an original in its own form. So coming back to AI, as and when AI creates something which is so original and distinct from its ingredients, then the question comes up, is it original?
I'm sorry to be stressing the AI question. Just a quick follow up. Are I know we have institutional limitations, but is the nature of copyright being output focused rather than process focused?
I didn't understand that.
So you're talking about the output of an AI being distinct and original, right? So why are we focusing that much on the output of AI rather than the process through which it arrives at that creation? So the
Because
process of creation to me is what is original about any piece of art. It's the process of the painting, it's the process of the writing. It isn't the written information or the art itself.
so that is how copyright has always been. No one has actually looked at the process. They've looked only at the resultant product. That's how copyright works. Patent and the way in which it is created, that comes under a different sort of engineering.
No, because just as one last closing remark to me, at least, would be that there were artists who existed from the beginning of time, since humans have existed, right? And when there wasn't art for them to look at and be inspired by, they still created art. We do
I
not.
don't want to answer that because I don't think there was this time when art began.
No, of course not. But there was inspiration drawn from thing that wasn't art. It was drawn from nature. It was drawn
Always,
from,
no?
but
See,
AI doesn't do that. AI draws inspiration specifically from other visual imagery that has been fed into the system.
like that, okay.
So there's been a lot of discussion.
1 minute. We seem to be recorded, so all of your voices have to be heard.
There seems to be a lot of discussion on copyright around AI globally beyond the discussions in this room today. Have there been no judgments or progress or at the global
Not in
level?
India as yet.
But at the global level, I'm sure there has been, some
See,
indication as to where this is going.
process of adjudication is very slow. Opinions have to be expressed. They have to be expressed in a structured manner. There has to be precedent to it. Firstly, it has to, in AI, I can tell you, it has to start with an understanding of what AI does. Does AI generate originality in the first place at all? So again, on a case-to-case basis, maybe this is original, maybe something else is not original. We have to see.
I think there have been plenty of cases already around copyright in AI globally, but I'm not aware of where they have gone, but there have been plenty already.
Okay.
At least in terms of inputs as well, from a data standpoint, the publishers in the US, for example, New York Times, etc., they have actually filed a case saying that they need to be paid for it. So at least on the input side, there are clear, I think, precedents being set
Okay.
legally. But on the other side, on copyright, there has been plenty by artists, by,
That has been there, but generated via AI, I don't know.
around the AI spectrum.
AI
Yeah,
space.
specifically.
Yeah, that I don't. I'm not aware of
Yeah.
it.
Maybe you can read up on those and
Yeah,
get your
I'm
question.
not aware of AI having generated copyrights. Which is why she knows the will respond.
I'm going to come back to your I'm going to come back to your publications and a sentence you made. You said an artist for what the viewer takes away and not what the artist thought about.
Correct.
Trust me, Ganesh, the most interesting part of your volume 1 and volume 2 is how Ravi Varma thought
Yeah.
of his paintings and what brought about his paintings. So it is really the reader's interest was to know what Ravi Varma thought and how he formed his pictures. So I think that statement in its
I was
totality,
mentioning that there is another view.
another view. Yeah,
There is
I understand you were talking more in the legal sense, how it is being viewed. But I just wanted to emphasize the greatness of your book, which is such an eye opener for people like me to read and understand what Ravi Varma thought. And because it's so well researched and so well explained, how he took pictures from the Western art
Yeah.
and different forms of art, especially those horses. Incredible.
Yeah.
The number of horses and the views. So
Thank-
well done, Ganesh. It was
Thank you.
absolutely brilliant. Thank you.
So if any of you all want volume 1 and 2, they're available there for sale. Any other questions? Oh, yes, there's a link.
So I think going back to the the argument that you made about the intent of the artist and how where what is what do we actually take away, whether how important is the like how relevant is the intent of the artist versus what the reader or the viewer takes away. I think there was a case, I'm not sure if it was a real case. There's a movie, a Marathi film called The Court, where a poet was questioned. He was taken to court because he was um, questioned on the basis of igniting or leading to the suicide of a manual scavenger through his poetry, through his work. I think it's a real case in Maharashtra. I'm not really sure about that. I think, and then oftentimes I've seen, at least this was one example of how the artist is questioned on their intent itself. The intent of the artist itself is questioned. Here it was from a legal standpoint or from any other standpoint, whether it be to have like push a particular social narrative or to push some, in this case, to push someone to commit suicide. then how do we really see this
I suppose it
argument?
depends on what finally happens. If and this is where I think the law has long said that, you know, if you're inciting particular people to do things which are at the end of the day illegal, then yeah, you come under fire. If you incite a community to do something, or you incite a person to go and do something,
But
then
then again, wouldn't that be a question of intent? How do we really know he intended that?
that is legal intent. What he was asking was artistic intent.
Yeah, I mean, from artistic intent itself, from that perspective,
depends
how
on
do we question an artist's intent is my.
So if you were to look at Ravi Varma, which is what I think one of the ladies asked me, was that did Ravi Varma intentionally do something? Ravi Varma didn't, but the Ravi Varma press did some things. Then there were later people who made cartoons out of it. For example, the Hindi Punch. There's clear intent in what they were going to do. So did the artist intend it when he painted Radha? No. Was the press doing it when they printed the chromolithograph? No. But what, did the Hindi Punch have an intent? Yes. And they had an intent to come out with a particular thing. So yeah, it depends on who is playing with that particular image. Is that all? So thank you, everybody.